Okay. Hi, everybody. Welcome to our panel regarding navigating regulatory and employment challenges in the sharing economy. Just to start out by way of background, my name is Andrew Klungnis. I'm a partner with Brian Cave and specialize in the area of technology transactions and counseling. The panel members will introduce themselves as we move forward here. But just by way of background, I think at this point, we all know more or less what the sharing economy is. It's here. It's a huge part of our life. Many of us have probably taken a ride-sharing service, maybe even to this conference. When we go on vacation, we don't necessarily stay in traditional hotels anymore. Oftentimes, we're guests. We stay as locals. We want to find childcare. We want to, we look to platforms. We have things that we want to have fixed around our home. We turn to TaskRabbit or Handy or other apps like that. We want to walk or board a dog. There's an app for that too, and usually it's a sharing economy platform. So it's something that's really taken off, and why wouldn't it? Given the efficiencies and cost savings and really just the fun that can come from it. But with the success of the sharing economy, there's a downside too, and increasingly regulators are paying more and more attention to what happens. Some regulators have a vested interest, sometimes an even overt interest, in protecting legacy business models at the expense of newer and innovative and frankly often better ones. Other regulators are confused or overcautious and therefore try to apply old economy regimes on new economy businesses. But at the same time, things are not all bad because some regulators are actually a bit more proactive, a bit more forward-thinking, and willing to act in the best interest of consumers. So I guess with that all in mind, we have a panel here today to discuss some of the specific challenges and success stories and maybe sometimes frustrations that have come with this. So with that said, I'm going to have each member of the panel introduce themselves and maybe give a few words about how their practice specifically relates to this topic. So,
Hi, Lonnie Mahanta. I lead the labor and employment team at Lyft to deal with internal employee issues, and then also sort of all the legal issues that arise from the independent contractor status of drivers, and a lot of different areas that comes up in.
Hi, my name is Irene Liu. I'm the general counsel at Checkr. For those that don't know, Checkr is a technology API company that does background checks for a number of sharing economy companies. And we do background checks for a company like Uber and other companies as well, too. And from a regulatory standpoint, I actually worked in the government as well, too. I worked at the Federal Trade Commission in the Consumer Protection Division, and I also worked at the Department of Justice as a prosecutor.
Hi, my name is Renee Lawson, and I'm Deputy General Counsel at Airbnb, and I oversee 4 verticals in our legal department, the policy, legal operations, litigation, and employment.
I'm Rebecca Eisenberg. I have a boutique law firm where I advise startups and entrepreneurs on mostly employment, compensation, regulatory compliance issues. I was previously general counsel of 6 different startups, Reddit, Trulia, Pure Digital, which is the flip video company, AdBright, Vouch. And I spent 6 years at PayPal in the early days, 2001 to 2007.
Well, with the panel introduced, I guess I started off by saying the sharing economy is here, and I gave a few examples of some of the companies in the space, as did our panelists. But just because we're all lawyers and we like to define terms a little bit, maybe we can talk for a minute or two about what specifically the sharing economy is. I guess, Rebecca, what does the sharing economy, what comes to mind, or how would you define it?
Well, I guess one of the things we were talking about at our meeting earlier is about sharing economy companies are often disruptors that allow individuals or maybe small businesses to sell excess capacity or to match possibly a service provider with a client who needs service providers. I think what's unique about sharing economy companies, well, actually something that's not unique, that's similar to previous companies, is that they tend to be disruptors. They tend to have businesses that didn't exist before, and I think that's one of the many reasons why regulators don't really know what to do and don't really do a good job with them overall.
Would anybody else have anything to maybe add or refine to the that definition of sharing economy?
From Lyft's perspective, I mean, one of the things that we think about a lot is drivers and passengers are our customers, users on both sides of the equation, and then we're a platform that's sort of an intermediary, and I think that's one component that's specific or relevant to the sharing economy. Other kind of distinctions that come up, sometimes we're talking about the sale of a good versus a service that's being provided. That those are different definitions that can narrow down the group that we're talking about that's covered by the sharing economy.
So one thing I would add is it's interesting. We've now have this dynamic going as traditional economy, new economy. If you think back one economy earlier, perhaps, this idea of consumers and the providers of services finding each other is actually unbelievably traditional. So there weren't always hotels. Where did people used to stay? They would stay in roadhouses in people's homes. There were inns that were that's what you used for resources that were out and available before this concept of a commercial hotel. And so, one of the things in the world of Airbnb is if you think about, the story of Joseph and Mary and where Jesus was born, it's the original sort of Airbnb concept, right? So this idea that it's all very new is an interesting one, and it's a dynamic that you need to really, as I say, turn the Rubik's Cube to understand how the pieces come together.
I was when you made the comment you made about it not necessarily being a new business model, the no quartering of soldiers amendment came to mind, but you've got me beat by a few millennia there with your historical reference. So I just to sort of add to that or to wrap it up a little bit, I would say that it really is characterized by a buyer on one side of really services and a seller on the other and an intermediary platform in the middle. And as Renee says, the more you think about it, the less of a new idea it is and the more of an old idea it is, but it's just made that much more accessible and that much more efficient by modern technology. So with that in mind, most if not all sharing economy businesses face essentially the same challenge, and that is that old economy regulations, whether it be taxi or livery regulations or hotel regulations or some others that we'll talk about, are imposed on these new business models. And I guess with that in mind, Renee, how do you find navigating the various rules and regulations around hotels and as they may be applied to Airbnb? How does that play out in your practice?
Yeah, so I think it's obviously a huge piece of what I do, a huge focus for Airbnb as a company, because we're at the intersection of maybe one of the most intimate things in people's lives is your home, right? And so the idea that should be regulated when it's made to public use is not that foreign. And there are very strong voices from the hotel industry and the regulation that may apply to the hotels. But there are equally strong regulatory interests and stakeholders in the areas of land use, for example, health and safety, the policing function of a locale. So there are lots of different regulations that could apply. And frankly, I think Airbnb has been very open in saying regulations should apply in this context when they are thoughtfully done and when they make sense for all involved. So we have a huge team that works on regulatory issues globally, and each country, each locale is very different. But what you need to think about is, in that context, who are the stakeholders, what are the interests, the hotels being one.
Any other regulations come up for Lyft?
Yeah, I mean, we're definitely subject to a wide variety of regulations. It's actually very highly regulated. We wouldn't about it in that context, but it really is a regulated industry, ride sharing. These days, you know, in almost every market that Lyft operates, we're domestic only, where we are regulated to some degree, and I think in every jurisdiction.
Yep. How about you, Rebecca? Are your clients faced with other sorts of regulations, be it accessibility or discrimination or anti-discrimination, I should say, or?
Most of my experience with this has to do with the fintech.
Yes.
And PayPal, and more recently Vouch, which is a online loan site. Is that, at least I don't know if this was your experience. Well, first of all, at PayPal, we didn't even know what regulation applied to us. You know, we weren't a bank because you didn't have to keep deposits. You know, ultimately, we, thanks to letters from attorney generals of various states, figured out a money transmission company. But filling out those forms to be regulated, to actually register, you know, was close to impossible because we didn't do anything that they asked. You know, we weren't Western Union. We didn't have, you know, offices like that. You know, the forms didn't even apply. And even more recently, a year and a half ago at Vouch, to finance online loans, getting a lending, you know, a license, the forms didn't apply. So it's you know, for me, it's been mostly frustration. Even when you want to comply, I don't know if any of you have had this experience, like actually filling out the forms can answer the questions. It's kind of NA. I don't know if any of you dealt with that. I mean, you'd think maybe for hotel-related laws or...
But we don't consider ourselves hotels, right?
So
it's because
so we were volunteering.
you don't quite fit in any box.
Right. So if they required you to register as a hotel, I think you'd find it really frustrating.
How about one issue that many businesses, online or offline, face are accessibility issues? I know Lonnie Lyft has dealt with that as well. Do you have any thoughts on those challenges?
I mean, there's a couple different ways that it comes up in our context. You know, there's app and website accessibility standards that need to be met, which make a lot of sense, generally applicable. Figuring out exactly what the standards are and how they apply to your app, that's, you know, one complicated process that we're dealing with. And then we also have issues with accessibility for, say, blind users on our platform, and service animal accessibility, and what laws apply, and even outside of what laws apply, what's the right thing to do? How do we make sure that all of the community is being served, that drivers who are also part of our community understand what their obligations are, what Lyft, what making the platform accessible for everybody that needs it. But those sorts of issues around public accommodation or public transportation, Title III of the ADA, how exactly those overlay on the platform is one question. But then separately, what are our policies and what do we want to do? What's the right thing to do? That's sort of another component of thinking about those issues.
Yeah, it's a very interesting point, as many sharing economy companies may say, and rightfully so. I'm not a hotel. I'm not a taxi cab. I'm not a whatever. I'm not a dog walking facility. I just help people who want to walk dogs find people who have dogs that need to be walked. Sometimes that argument can eclipse the fact that there are certain regulations that are plainly applicable, and on the Lyft side of things, for example, maybe ADA regulations would clearly apply to, say, a website.
Yeah.
Right. So I think a best practice is to not only consider regulation in terms of the thing that the regulators might think that you are, but to consider and hopefully comply with regulations that are clearly applicable to you, even if you take your, most, I don't want to say self-serving, but most refined understanding of who you are and what you do. And sometimes it could be a much easier argument to make that you shouldn't be subject to this set of regulations if you followed the regulations that are plainly applicable to you in your own business. Another sensitive issue is discrimination. Renee, has Airbnb dealt with anything with regard to the body law that prohibits discrimination in various degrees?
We have. I mean, I think 2016, there's actually a lot of press around that topic for Airbnb. And it predated me joining the company, and I am and was very proud with the way the company handled the topic generally. For us, we always had, as part of our terms, that discrimination has no place in our community. And when someone made allegations that they were subject to discriminatory practices, we enlisted a task force, including a former trial lawyer from the ACLU, Laura Murphy, and decided to look at this issue on behalf of the company, on behalf of our community, and see if we could try to make some headway. We can't change what every person says and does, but we can take a stand for what our community should stand for and what we as a company stand for. And so, interestingly enough, a lot of lawyers probably would have counseled against doing precisely what Airbnb did, which was to come out very strong in the words of anti-discrimination, required all of our users to consent to a new policy that they would not be engaging in those practices, and we assembled an internal team to basically have an escalation point if these things were surfacing so that we could prioritize their treatment, which, some people would say amounts to a bunch of admissions. I, as a continuing litigator, I was going to say former, but I'm still a litigator, maybe a former trial lawyer, think it's the opposite. I think this really stood for what our values are, and we have actually a pending class action lawsuit in this space. And we got contacted about a radio program that they were putting on. The plaintiff's lawyers wanted to talk about this new lawsuit they had filed. They contacted us to see if we would put somebody on the radio, and I'm sure that 9 out of 10 lawyers would say, oh no, you can't possibly put somebody on the radio to talk about this topic. We hadn't even appeared in litigation yet, and we made the exact opposite decision. Laura Murphy went and spoke about this. We feel absolutely strongly about our stance on anti-discrimination and making our community open and available to everybody.
So what do you do for enforcement then?
So we have, within our customer service team, sort of a squad that has the ability to address these as they come in and get people rebooked into other listings to look into it. We will do takedowns as required, take people off of our platform. And so we've put some energy behind the policy.
Does anyone, Irene or Rebecca or Lonnie, do you have anything else to add from maybe your perspective on discrimination or otherwise?
I mean, it's something similar to what Renee was saying. It's something that is antithetical to the values of our platform.
Mm-hmm.
Making sure that those policies are adhered to across a large number of users is a challenge, and it's something that we're continually working on. We have strong anti-discrimination policies and are continually working to try to make sure that there isn't discrimination happening on the platform, looking at things as individual complaints that come in through our trust and safety team, but also looking systematically across, looking at our data to try to understand if the data tells a story. So there's sort of multiple levels that we're looking at things and trying to address the problems.
Great.
If there are any.
Yeah, I have opinions on this. That it's like being not at one of these companies. I just looking at it from the outside, I think it's going to be close to impossible for either of these companies or any of the similar ones, Uber, et cetera, to argue that the civil rights laws don't apply to them. I think it's, that just like a cafe, coffee house, any company open to the public is required not to discriminate on basis of race or, sex and, et cetera. These companies are also subject to those same laws. So I think it's, internal policies, trying to move the liability over to the customer. I think ultimately, actual, Title VII style investigations are going to be required. An actual Civil Rights Act, as described in the regulations, procedures are going to be required. I think I just can't imagine any of these companies winning, stating that these civil rights laws don't apply to them on a state or federal or local level. I mean, that's my opinion. I just don't even see the argument. I don't think it's even close, but it's good. I'm glad that, it's that the companies are voluntarily complying, and that's, I think, extremely important. And I think if you weren't, you'd be hit with a lot more lawsuits, if you didn't have that position. terrible.
Well, sometimes on a panel one may agree to disagree, and
I don't think
there
they're
may or may not be a
necessarily
little-
disagreeing. I just think they can't, being at the company, you can't speak as freely just out of common sense and, all that, and loyalty to the company. But,
So I can speak super freely on this,
Yeah.
actually, because I feel
Yeah.
pretty strongly about this. I feel absolutely strongly about our anti-discrimination policy, and feel strongly about the enforcement actions that we're taking. But I don't agree with you that your view is that the common sense approach is that all of this applies to you as a
you
platform.
don't think that the civil rights laws apply to you?
I
Civil
think
Rights
there-
Act of 1964?
I think there is a continuing question on what does it mean to be a platform. And that can come up around civil rights laws. I know we're going to talk
I'm
about
not saying what it
CDA in
means
a
to be a
minute.
platform. I mean, but yeah, okay, so
But let me give you an example. Airbnb, does not control when a host, does not always control when or ever control when a host accepts a guest. I'm not in
Yeah.
that exchange. So you reach out to me as a potential guest to a host, and you say, I'd like to book your place. I, as a host, decline.
right.
I don't see that exchange. I'm not involved in that exchange. And there can be all kinds of reasons for that declination.
Absolutely.
So the question is, as the platform, if that host is engaged in some sort of nefarious conduct, whether you think it violates the Civil Rights Act or otherwise, does the fact that I have facilitated that communication put me in the position that the law applies to me?
Well, because you actually have these terms of service that you make your hosts agree to, and because you actually remove hosts from your platform if they're in violation of these specific principles, that would actually exempt you from the CDA's protection in that area, at least in my understanding. Whether or not a particular plaintiff could win in court is a completely different question. I mean, it's always hard to prove discrimination. That's a very, very difficult
So I think
lawsuit.
you took a huge leap by saying the CDA doesn't apply.
Well,
But
in that specific way, because to the extent that you're an editor and no longer just a platform, to the extent that you, which I think is good, to the extent that you actually control who is and is not allowed to host sites, on this particular basis, I think it's, I think it ultimately that's going to be a losing argument to say that you're protected as a platform when you actually edit.
So the law
Okay.
actually is counter to that on the CDA. So we are allowed to exercise editorial rights and still have platform immunity under the
Right. I
established
mean,
CDA law.
yes, I worked at Reddit and
So-
at
Yeah.
PayPal.
we're gonna-
I mean, yeah. So, but I
Down the
think,
Let's-
CDA
you know what,
but civil,
let's,
but yeah, I mean, I think ultimately,
we've had Star Wars. Let's have The Empire Strikes Back when we
Yeah.
get to the CDA. But let's move to a slightly different aspect of our topic. Whether it applies to a platform or not, well, let's just say, how is regulatory risk assessed as a platform? How do you take a look at a regulation and say, does this apply to my company? Does this apply to my platform? What are the risks if it applies? What are my chances of avoiding it? How do you assess a given regulation and its risk to your business? Why don't I start with you a little bit, Lonnie, and then we can go down the line, particularly because Irene hasn't had a chance to speak yet.
Is there a particular aspect you're thinking about here in this?
Well, let's just
topic?
say you're moving into a new market, and there are transportation laws on the
Right.
books.
Yeah.
Where do you go even from there?
Yeah, I mean, this is probably fairly obvious to everybody, but you read the regulations, you take a look at it, and you look at the plain language, you see if
Right.
it applies to you or not, right? I mean, like I said, it seems fairly obvious. I think what often happens though is that there is a stance that has to be taken. You have to look at it and you look and see if this is something that applies to taxis. There might be some regulator or agency official who thinks that per se applies to any kind of car service involving cars. That's not the stance that Lyft takes. That's not the approach that we're going to look at. That's not how we would look at things. And I think that there's definitely an element of how risk tolerant or risk averse the company is going to be when they're making an assessment about application of a regulation to our company.
Got it. How about you, Irene, as a general counsel and a former regulator? What are some thoughts you might have about enforcement and risk reward vis-a-vis regulation?
So, in terms of enforcement, I think that for us, for example, Checker is a background check company, and so we're regulated by the FTC as well as the CFPB because Fair Credit Reporting Act applies to us. And so, in that sense, we have to make sure that we're compliant with the FCRA. And not only that, what I've learned once I joined this industry is there's a whole host of mini laws as well too, that are local and state, and so we need to make sure that we stay compliant. And I think it's, if you know that you're currently within the boundaries of that law, I mean, I think it's to the extent that you want to be as compliant as possible because there are regulators, there's also plaintiffs' attorneys that are all keeping companies in check. And so I think it's really important that you make sure that you stay abreast of the legal developments in those areas.
So I know that I think that FCRA has different components, right? There's parts that you as a credit agency have obligations, but then the company running the report also has separate obligations. Like, how do you help your clients figure? I mean, do you have to help your clients figure that component out?
So actually, I'm here because I want to share three main tips actually for especially on-demand companies and sharing economy companies. So what I realized when I entered into the space is how nuanced and difficult it is to understand the Fair Credit Reporting Act. And so it's actually a really interesting area of the law, and there are so many state-specific laws as well. But at a high level, if you are a counsel to an on-demand company, I think you should keep these three tips in mind. The first thing is you need to have a permissible purpose before you conduct a background check. I can't just conduct a background check in Renee because I want to. I need to have a legitimate purpose. And oftentimes the legitimate purpose is under the FCRA for even on-demand companies is employment purpose. And you must be like, whoa, I'm not an employer. Like, don't say employment purpose. I've contracted out of it. I don't want anything saying employment in my contracts or anywhere. But the FTC actually views employment purpose broadly than just employer-employee relationship. It actually includes independent contractors. It also includes volunteers as well. So regardless of even if you're just engaging independent contractors or volunteers or employees, your purpose under the FCRA is employment purpose. And if that's your purpose, there's a whole host of obligations that also fall under the FCRA, which is quite interesting and very nuanced as well too. And so the two things that I want to make sure that you take away from this, at least from a background check perspective, and background checks I think are important, again, because especially if you're inviting people to your house or if you're having them walk your dog or if they're driving you, I think that's a very important component. And so the first thing I really do think that it's important to do is look at your disclosure form. The FCRA is very clear that your disclosure form, which is a form that basically states that this company is conducting a background check on the applicant for employment purposes. And that's all it should really say. The FCRA is very clear in saying that the disclosure should consist solely of the disclosure. It should be clear and conspicuous and should have nothing else. It shouldn't have a liability waiver or any other terms. And if you do, you're just inviting plaintiffs' attorneys to come to you. And there's a whole host of litigation and class actions just on the disclosure form. So I would advise that to the extent that if you don't know what you're doing with your background check process, just double check. Is the disclosure is it consisted solely of disclosure? And are you obtaining proper authorization for the background check? Are you obtaining the consent? And then secondly, the other thing that I found really interesting through learning once I joined Checker is in an employment context, again, even if you're engaging independent contractors, you need to give like a heads up notice. It's called a pre-adverse action notice. And so if you decide not to move forward with an applicant, you need to send a pre-adverse action notice. This is basically like a heads up notice, like heads up, applicant, we found something in your background check, we don't really like it, and we're probably not going to move forward with it. And if that's the case, you need to give this pre-adverse action notice. It's required by the FCRA. And right after you send it, you can't just terminate them. You have to wait. Under the FTC advises 5 business days between the pre-adverse action notice and the adverse action notice. And the adverse action notice is basically like, hey, we're not going to move forward with your candidacy. But you have to wait at least a minimum of 5 business days. And as Lonnie and I were talking before, there's also state-specific notice requirements as well too. So Philadelphia, for example, requires 10 days before you actually terminate someone. And the safeguard for that period is in case you decide and you give a heads up notice, in case the applicant sees it and they realize, actually, no, you got the wrong information in my background check, they have that opportunity to dispute it. They can also contact the employer and tell them why it was wrong. So it's sort of a safeguard that was put in law to protect the consumers like us. And so I think it's a really great safeguard, but it's also another hotbed for litigation. And so I think it's another area that plaintiffs' attorneys are attracted to make sure that you're following this pre-adverse action process. So I would highly encourage that, to the extent that if there's a takeaway from a background check perspective in this area, is that you do fall under employment purpose. Check your disclosure document to make sure that it solely consists of the disclosure, and make sure your company's doing pre-adverse action. We have tools. You were asking, what do? We advise companies. We provide advice to them. We have tools that make this compliance really easy, but not all companies do that. So just make sure that you check that process, because it is definitely an area that plaintiffs are drawn to.
You know, as a company that has to run these types of background checks, the compliance component is complicated. You know, we have a company that, you know, helps us manage things similar to Checker, but implementation is done through our own platform. We have product managers and engineers that implement these things. So, you know, complying with the federal act is one thing, relatively easy to implement. But having these overlaying state mini FCRAs that also that we also have to comply with, and city regulations as well, it adds a layer of complexity in trying to figure out how to make those automated processes compliant across the board in all the areas in which we're regulated.
I'm just fully sold on Checker at this point.
That was my job.
Yes. I guess, Renee, I mean, without getting too deep into necessarily, obviously nobody's going to reveal anything privileged, but just saying, just from a general practice perspective, do you, in analyzing regulatory risk, might you look at the penalties for noncompliance or the operational challenges associated with a particular regulation to determine how aggressively you might argue that your client would be outside the bounds of it?
Sure. I mean, I think that's what we all do
Right.
in-house and elsewhere is take a look at the landscape and figure out what the risk equation looks like. I mean, for a company like Airbnb, there are a myriad of regulations that one could claim apply to some aspect of our business. The home sharing piece, the more traditional thought of that is just one piece of that. We also have Airbnb payments, so all the payments pieces apply to the company. We have rolled out experiences, so it's not just about home sharing anymore. And so as our business becomes broader, the scope of regulation also grows. And that's our job. I mean, I've got two of my colleagues here on our product team who are awesome on the front lines who are every day looking at the risk equation and looking at arguments that someone might make that something applies and trying to make a decision of, do we think the risk is high enough?
Great.
I mean, Andrew, can I just?
I was just about to, yeah.
Yeah, I think this may be something we all could agree with, is that usually it's not the lawyer who makes these decisions, of what laws you're going to comply with, and what a lot of the job, and I think for most lawyers, we would prefer just to comply, but complying with laws, being extremely conservative about it, like outside law firms usually would want us to do, it can be extremely expensive. It can require headcount. It can require engineers. And getting that on the roadmap can be extraordinarily difficult. I mean, sometimes I felt that 95% of my time was just spent in internal negotiations with the CEO, with the CTO, and COO about getting resources moved over to product initiatives and changes that would actually help us get more in compliance, in strict compliance with the laws. I think it's close to impossible for any startup to actually launch in strict compliance with every single law. There's just not enough money going around, and when you owe obligations to your venture capitalists, other investors. It can be pretty impossible to prioritize that. Often you just can't until the letter comes in from the attorney general, or until the phone call comes in from the federal prosecutor, or whatever it is. And then, in some ways that can be very helpful, because you finally have a real argument of urgency to have the company prioritize what you've been advocating for, possibly for years. I think it's, but sometimes I think if the lawyers actually ran these companies, they'd all be run into the ground, So it's good that there's the gas pedal and the brake.
Do you find that you have similar, to the three of you, do you find you have similar sort of risk-reward determinations to make, despite being at somewhat more well-established by Valley standards companies? Yep.
Definitely. I think for us, we're 3 years old, and again, I just came in a year ago, so I've really had to revamp all of the compliance practices, and they've actually done a really good job with compliance, but it was helpful for them to have someone come in to look at it from a fresh perspective and really help the CEO understand the real risks. And again, because there's not only FCRA, but many FCRA, and trying to figure out the risk of complying with the federal versus the state versus the local. And so having a legal counsel there to help assess the risks and the rewards, I think is really helpful from an in-house perspective. And I agree, while I think business partners make a lot of the decisions, I think it's our role to really help them assess the risks and to make sure that they understand which ones are the highest priorities and really help guide them with that business decision. So I think it's really important that you weigh the risks for all of the different types of laws that you're subject to.
And we can't really even make recommendations, I think, without their input, too. Something that might seem really inexpensive to us turns out that it requires 10 engineers, and 6 months, and that goes into the risk-reward, equation. So it's definitely a collaborative process.
I've been at Lyft for a little over 2 years, and even in that time, we've seen the spotlight come on a little bit more. And so I think, also when you're advising about risk, some of it is also looking at how much of a target you might be from some agency or an AG or whatever it is. So the advice that was given 5 years ago might have a slightly different approach. You're more likely to have an enforcement action or a class action brought against you when you're more established. And
Yeah.
Got it. Well, moving from assessing a regulation to maybe some strategies to avoid one, and I think one that's very prominent out there, and we started to allude to it, is the Communications Decency Act, which in its heart essentially provides that platforms are not liable for content placed on those platforms by users. Platforms in the CDA are described as OSPs, which gives you a little bit of online service providers, which gives you a little bit of a sense of history there. And I know, Renee, Airbnb has really been at the receiving end of probably the worst CDA decision out there. Not to bring up difficult topics, but we're here to unpack some laws. I guess could you speak a bit about maybe the metes and bounds of the CDA as you see them as they might apply to sharing economy models?
Yeah, that could be a whole panel
Yes.
right there. So, sure. In a nutshell, you've summarized it, is that when you're acting as a platform, what's going on between a guest and host in our circumstance or users in other platform environments, the platform does not have liability for the individual user content. And the courts have actually been pretty expansive in recognizing that body of law, that principle, and in developing this body of platform immunity. And so, that's kind of what's allowed apps in general,
right,
and websites in general to grow, and that was the whole principle behind the law from a congressional perspective. What I will say is that a lot of people who don't live in this environment, in this tech environment in which we operate, it's hard for them to grasp this concept.
Right.
Because it does not apply in traditional bricks and mortar necessarily. Mm-hmm. And so this is a place where the law is unique for what we're calling new economy. That can come up with some pressures when you are in front of a judge or a person who operates outside of this bubble in which we operate. And I wasn't there for the San Francisco case, except for it went into mediation, so I was there for that portion of it. But Judge Donato in San Francisco Federal Court, Northern District, issued a ruling that, in my opinion and many other people's opinion, is wrong. And wrong because it goes against this body of law. It is very different, I think, from where the CDA has been. But I think what Judge Donato did was he was trying to solve a problem and found a conflict between facts and perhaps what he viewed as common sense and this law. And I'm going to let you talk in just a minute. Oh, go ahead. Yeah. So that's, I think, what you're going to see without divulging privileged information. That ruling is still on the books, and we ended up, to Judge Donato's credit, he sent the city of San Francisco and Airbnb into a court-ordered mediation. When that decision came down, we were in mediation for 5 months with Judge Corley. So if that gives you any indication of how hard-fought this was, 5 months with Judge Corley is no small feat. And ultimately, the parties came up with a settlement. So the CDA ruling, while still on the books, we absolutely still believe is wrong. We will continue to rely on, and we do continue to rely on CDA and platform immunity. But there also is the collision between what happens in a courthouse and what happens in the real world. And I am at a company that is working in the real world, and that's where we will continue to focus our efforts. So there's a little bit of a intellectual argument one can have, which I'm certainly happy to have after this, about the CDA and that decision, and also what you as an in-house lawyer have to do to make the world safe for your company.
Right. I mean, I'm without making any statement about that particular ruling, because I am a big fan of the CDA, I'm a big fan of free speech, which I understand it to be its purpose, actually, I think that we're not just about protecting our companies, but we're about protecting human beings, our citizens, our children, our individuals, who are subject to, assault, racist violence, etc. And when and I'm not saying I'm a big fan of Airbnb. I am. So I'm not saying this is Airbnb, but for anyone who watches HBO's Silicon Valley, I think they actually had a really good example of when a company crosses the line to violate the law, even though it's a platform, and there was a video chat application that was being used almost entirely by children. Now, this video chat application can't claim immunity from the law and from complying with the laws that protect children because it's a platform. So there are limits to that. And for example, when we were at PayPal and I was working on the IPO, PayPal voluntarily, in part for urging from our underwriters and for a lot of other reasons, we voluntarily decided not to fully cut out any of our gambling business. Because to the extent that a platform is being used to facilitate something that's illegal, the platform cannot claim CDA immunity. Similarly, we voluntarily decided to stop with our adult businesses, which I think later may have been reopened after we became part of eBay, but I wasn't involved with that then. So again, to the extent that there's child pornography, a site cannot claim immunity because it's a platform, and having spent the amount of time at Reddit I did, let me tell you, can be some really, really ugly stuff that goes on the internet, that goes on in platforms, and not all of it is protected as free speech. Not all of it is protected as, as legal businesses, simply because it's facilitated by a platform. So I think that a lot of these goals, and I totally agree the courts are still working all this out, the legislators are working all this out, regulators are totally clueless. But, I think that the goal here is to protect people when they're going in to stay at other people's homes, to protect them from racism, to protect them from violence against them. and to make the homes, available on a legal, equal opportunity, civil rights compliant way. And I think that is going to eventually shake out. I don't think this recent lawsuit, and I think anything led by plaintiffs' lawyers with, class actions tends to be not helpful, right? But I think that, this is going to shake out eventually.
So I think I just want to double click on one thing there. In the San Francisco lawsuit and in other places in the U.S., to your point, regulators don't yet have the path, and we're going to talk a little bit about that. But those cases that we have been involved in have been talking about legislators adopting regulation to impose specifically against platforms like Airbnb for advertising, for speech. So
terrible.
Exactly, and for advertising, short-term rentals in this instance, that haven't gone through in San Francisco registration. So we aren't talking about child porn. We're not talking, there are things that go to the police state that I think are very different from the type of regulatory activity that we're talking about here and appropriate regulation. Airbnb believes in appropriate regulation. I started off, but regulators have been challenged to figure out what that is, and they're subject to a lot of different pressure points out in the world that lead to what we believe to be
by the hotel lobbies.
By the hotel lobbies.
Who have all the money, right.
So they adopt regulations that are misguided in many instances.
So yeah, we agree on that.
Yeah, I would just sum up with a client of mine in a huge CDA lawsuit in New York. It's involving a dating app rather than a sharing economy, although I'd say geolocation dating apps are a very close cousin. I guess what I'd say is I think actually the Telecommunications Decency Act is probably the single most important legislative tool, apart from maybe the tax moratorium, that's allowed us to all be sitting here, with jobs at very innovative companies and has allowed technology to proliferate. The immunity is actually very, very broad, and there's some enumerated exceptions for IP. There's there's the roommates.com case, which kind of made up a novel type of immunity based on creating fields that allowed users to enter in infringing content, content that ran afoul of anti-discrimination laws. I'd also say that, as the firm that represents the National Center of Missing and Exploited Children, the protections vis-a-vis child porn are very front and center, and there's actually a very active lobbying effort going on to tailor a very narrow exception to the CDA for child pornography, which I think we all agree that that is something that should be punished to the fullest extent of the law. The rub really becomes, if you're a hosting company and you have billions of images, and you're a newish business model and have limited financial resources, to what extent are you really responsible for combing through these things? And that's something that's being discussed. But anyway, it's all to say that if you're a sharing economy company or another platform of any type, actually taking a long, hard look at the CDA as a source of immunity, but maybe knowing that bad facts can make bad law, keeping that in your back pocket might be a best practice. So with that topic moderated, let's move on to another issue. One particular issue that I think we've seen a lot of is users of a platform, meaning the service providers, the taskers, the drivers, the hosts. Every platform, of course, has its own nomenclature. Can be deemed to be employees of the platform despite making their own hours and some of those factors. And I know, Lonnie, that's right in your sweet spot at Lyft. So maybe you can give us a few words there.
I think at a high level, one issue that we've sort of already touched on in different areas is that employment law lives at a lot of different levels, right? There's common law, things that are enforced in the California courts, California's Borrello test, but then there's slightly different iterations of this test that live at the federal level. The NLRB has different ways that it looks at it. Fair Labor Standards Act also has another way that it looks at it. So there's a lot of different components, similar factors that are weighted in different ways. So from a compliance perspective, one thing that we're always looking at is understanding the test in multiple different jurisdictions and different fora. In California, I'll focus on that just because we're here and that's sort of where our big class actions have been. The main test is the control test, or the Borello test, which looks at whether the company controls the way the work is done, the manner and means of the work. So that's sort of the high-level test with factors that live under it, things that include, what level of supervision is the company providing over the work that's being done, who's providing the tools and instrumentalities for the work, what's the length of time that the work is being done, is it project-based or is it ongoing, how is payment made, is it made hourly or is it by the job, what's the belief of the parties. So there's a multi-factor test, which is always, makes it complicated as an attorney for the company trying to help other parts of the company sort through these things. It's a multi-factor test. Does one thing that you change, a finger that you put on one element, how much does that move the needle? That sort of counseling is something that, we're always thinking about on my team. As that test applies to drivers, there's a lot of different facts that go into the analysis. Things include that drivers completely choose when and where to work, if they want to work at all, if they turn on the app. There's no schedules. An important point that's sort of a detail but is important is that if somebody is in driver mode and a ride request comes in, there's absolutely no obligation to accept a ride. It's really important, right? They're not required to do work under any circumstances. There are incentives that can be done, things to incentivize people to drive, but there's not requirements to do so. Drivers own their own cars, they provide their own gas, provide their smartphone and data plan. Jobs are paid by the ride, not hourly. Some other little factors, drivers are free to promote their side businesses in the car. So we have lots of anecdotes of people that have granola businesses or jewelry businesses or their personal life coaches, people that are shilling their side hustles in the car as well. And then we also know that drivers work on competitive platforms. We're going to drive on Uber platform or Instacart or Handy, and so these are things that are not consistent with traditional ideas of employment. And that all sort of leads to these, this sort of, at least in my world, famous statement by Judge Chabriat of NDCal, where he talked about trying to fit a square peg into a round hole, and looking at 20th century paradigms of work and trying to put these new relationships and kind of shoving them into those old models. And there's no easy answers here, right? I mean, it's very clear from my perspective, but there's obviously still ongoing conversations and legal issues that have to be addressed in this space.
I have to tell you, as Santa Monica has become Silicon Beach in the last few years, I've been handed no less than 3 business plans by Lyft drivers for their startups. Yeah. So we've spoken about risk. We've spoken about the CDA and that being a possible avenue to avoid risk. We've spoken about risk-reward balance, whether at a brand new startup or, again, by Valley terms, established company. Let's talk about some best practices to reduce risks. Irene, you had given us some good detail about background checks. Have customers of Checkr and other platforms that use background check services found they reduce both regulatory risk and, say, practical risk?
We try to make compliance as simple as possible for our customers, and I think it's really important to find a solution that does that for you. And so one of the things that we do is, because there are so many requirements under FCRA, we've actually built a technology platform to do it for you so that the lawyers don't even have to think about it. And I think it's important to find really good solutions that will work for your on-demand companies in that sense. And I also believe from a regulatory standpoint, in order to mitigate the risk, I think, I worked in the Federal Trade Commission, and from a regulatory perspective, when I think about it, I think it's important to be proactive as well with the regulators. I don't think you want to wait till the day that they actually come knocking on your door with a subpoena or with a CID. I think it's really important, especially if you're in a new technology, new area, I think it's important to also proactively inform them about your business model. And I think Airbnb has done a good job engaging with the regulators as opposed to some of the other companies as well, too. And I think that kind of proactive relationship, I think, is helpful, and that's sort of the development that I've been engaging Checkr as well from our perspective as we're working with regulated entities as well, too.
Any other, there's various other practices out there, for example, rating systems and trust mechanisms. Rebecca. Actually, I'd be interested in Rebecca and Renee and Lonnie's views on these points, but have your clients employed rating systems, and have they found them, if so, have they found them to be effective?
You have. I mean, so we have too. I mean, I think that rating systems are a great way to reduce risk. They are. It's reputation tends to be a link between reputation and reality. Whether it's maybe not one-to-one. I made some notes that I think that what Airbnb is doing and Lyft is doing in terms of voluntary compliance is extremely helpful. As to takeaways and actionable. I think another thing, I didn't put this down here, is don't get your advice from a litigator. And nothing against litigators, but you
always get your advice from a litigator.
Yeah, no, I mean, I'm married to a litigator, and he and I both answer questions. We answer questions in completely different ways. I'm always like, oh, I really hear you. That must be so frustrating. Oh God, I feel you. He's like, dear Mr. and Mrs. blah blah blah. So I think often a soft touch is kind of what I'm saying. Maybe there are some litigators with soft touches. You probably have one. But don't when someone's asking you a question, don't come back fighting. Maybe respond in a conciliatory, maybe kind, collaborative manner. I also put down proactive lobbying. I think that's so important to, don't try to assume that don't assume that you're under the radar. You're not under the radar. I mean, although TechCrunch may not be writing about you or Recode or whoever, a class action lawyer often will be the one, unfortunately, but somebody has their eye on you, and they might be calling the regulators. So I would say don't assume that you can, kind of slide by without being noticed. Be proactive. Don't be afraid of tipping off the regulators. I can't tell you how many times I've, as CEO or, other internal executive have said to me, oh, I don't want to reach out to them because then they'll know what we're doing, and we're really in a gray area because let's face it, we're always in a gray area. So I think to be proactive and not be defensive is usually the better approach, at least in my experience. I think you all have done a great job, really.
Yeah, I think from our perspective, we've working collaboratively with regulators is a huge part of our strategy, right? The legal team and government relations team works hand in hand. We're trying to understand how the existing regulations apply to us, if they do. At the same time, talking to regulators to make sure they understand the business model of the company. Obviously, we all know what ride sharing is, but there's a lot of new markets, places that just don't quite get the nuance, don't really understand what we're talking about, and going in and explaining how it works, what the benefit is for the community. Those are things that really are very, very useful.
I would just add, use your biggest asset. For those of us here, for Lyft, for us, our biggest asset is our community. That's what we're about. If we don't have a community, then we don't exist. And so as passionate as I am about Airbnb, our hosts, our guests, are unbelievably passionate. They believe in Airbnb. That's why they're part of the community. And their voices carry so much more power than any litigator's voice could possibly carry, as strong as a litigator's voice is. And they will come out. They will come out and talk to regulators. They will come out and talk to legislators. And those are the people that those entities, those individuals, elected officials, usually will listen to, much more so than a lobbyist or a company. And so we spend a lot of time with our community, and our community comes out in strong force in various ways.
Do you agree with that, Irene, as a former regulator yourself?
Yeah, no, most definitely. I really do think it's by the time that the government agency is knocking at your door, that's a little bit late. And they've already investigated you. They have evidence against you. Like, by the time they're knocking at your door, they have enough evidence. And so now you're really coming out of, you have an uphill battle. Whereas if you proactively educate them about your platform, maybe even come out to them about some of the gray areas and try to proactively engage them about their perspective, they're at least engaged and can help shape to a certain degree. And I think it's helpful to be more proactive versus being reactive.
Got it. Well, that's a great place to leave it. right at the quarter of hour. Yes, please. Anyone who has questions, I believe you're. Yes, please. I think you're supposed to go to the mic as well if you have a question, just for the recording.
I understand the different regs that apply to hotels versus a homeowner, but I'm not quite clear on what the different regs are between a taxi driver or a taxi company. I understand you don't consider yourself a taxi company, but the actual drivers, what are the regs that apply to, for example, a taxi driver that do not, in your opinion, apply to a Lyft driver, or do they?
Well, I'll preface this by saying that this is not exactly my area, so I'm going to speak at a high level here. But yeah, I mean, there's regulations. So an example of some regulations that might apply into the taxi industry that we argue doesn't apply in ride sharing or shouldn't would be like fingerprinting, right? So some places require fingerprinting as a method of ensuring safety for taxis, right? But what we've had to explain to regulators and help them understand is, a lot of different components to that. One, the idea that fingerprints are the only safe method of understanding somebody's background. That's not really accurate. There are arrest records that aren't updated. They can have disparate impacts on certain communities. But also, that only looks at one piece of the safety component. So, Lyft has, rating systems. We have a trust and safety team. We also have the ability to, understand a ride from beginning to end in a way that a taxi doesn't. And so there's additional safeguards that might, there might be reasons why this idea that fingerprints are the only way to have a safe platform. Those don't apply. That reasoning is not applicable, and also can have adverse consequences. The fingerprints take very long time to run. The way the platform works, you need to have a quick onboarding process to provide access for people. Having a city agency that's backlogged, spending weeks trying to get through fingerprints, won't allow the company to work in the way in which it works, and doesn't necessarily accomplish the goal of having a safer platform. That's just one example, but that's the type of...
Sounds like fingerprints shouldn't even be relevant in taxis, right? I mean, it sounds like the whole area probably should be revamped.
It's a really hotly contested issue between fingerprinting and consumer reporting agencies like ourselves, because we support Uber, who's also using non-fingerprinting technology to background check. So a lot of cities are looking at this, and there's a huge lobbying by taxi as well, by taxi associations that are looking at fingerprinting and saying, well, it's a lifetime look back, and so potentially maybe they provide safer mechanisms, whereas consumer reporting agencies like ourselves are regulated by the FCRA, which provides, which from a regulator standpoint and from a consumer standpoint actually provides opportunities for people that's already served criminal sentences so that they have another opportunity. FCRA doesn't allow you to look back after a certain period, so that it provides certain people with criminal backgrounds to find jobs and to be able to work on Lyft and to be able to work on Uber, whereas fingerprinting, it may still be there. And so it has a disparate impact, like what Lonnie was saying. So it's a huge debate, and it's a lot of cities are looking at this. Austin was one of them that looked at this recently.
So fingerprinting is a city requirement, not a state requirement?
It depends. I think in a lot of locations, taxis are regulated at the city level. Like in San Francisco, I think SFMTA regulates taxis, whereas ride sharing is regulated by the California Public Utilities Commission.
Please.
I just have a question about how you give legal advice, particularly to your independent contractors who use the platform. Like, you want them to comply with the law, but they may be, legally unsophisticated. How do you talk to them and guide them about, how to comply with law? How do they register? How do they understand what discrimination is? I mean, how do you provide that legal advice without providing legal advice? I guess
It's a great question.
You want to talk about? We don't really fit in the independent contractor bucket, so I'll let you hit that.
Yeah, I mean, I think it's a very good question, but it's complicated because it sort of depends on what type of advising or what type of law you might be complying with. With regard to our anti-discrimination policy, in that context, we're not advising about what the law, what an individual's legal obligation is. We're talking about what we have said our anti-discrimination policy is and making sure they understand the way we conceive of that policy. tax might be an area where somebody might have questions about how to provide tax forms for their driving services. We have FAQ that provides high-level advice, not advice, information about completing forms and about the different information that's out there. But of course, we stop short of providing legal advice. We're not counsel for these individuals, and we really couldn't provide effective counsel for that large group of people. So there's sort of varying levels. A lot of it will be on FAQ pages, sort of high-level information, but we're not providing legal advice in that sense.
And I think for us, this is one area where we're able to get to rational regulation with cities. So tax is a good example. We have brokered a number of primarily transient occupancy tax deals with various locales to actually collect the tax on behalf of hosts and remit. It saves the hosts from having to understand this crazy tax scheme. And the cities love it because their coffers are then filled, and it's much easier to do at scale. So that's a really good example of where the platform can facilitate a transaction that the costs are diminished and there's no legal advice being performed. The San Francisco settlement of the Judge Donato, the aftermath of the Judge Donato decision, ultimately resulted in pass-through registration. Is the means by which we now have a safe harbor to comply with that existing ordinance. So we are able to facilitate, as a platform, a much more rational registration system by bringing technology to bear on a problem. So as one example, I think that platforms can utilize, particularly in a regulated atmosphere.
I mean, Renee, you were also talking about in your terms of service too, that because I think that might be part of the question, that about educating people that they can't prohibit families or restrict to a certain race or prohibit gender differently gendered or people. That's in your terms of service. Do you do that?
Yeah, so our terms of service have all that in a contractual context with our users, but we did do a huge education outreach with our anti-discrimination work and required actually affirmative consent when we rolled that out. So there are places where you do more with your community, and that's just a good example of where we did have a little more touch with the community on that topic.
Yeah, it's almost like you're having your own platform's rules and regulations that mirror those requirements imposed by law, and you're not necessarily telling any of the hosts or drivers or whatnot that you are to. In order to follow the law, this is what you have to do. What you're telling them is, in order to be a good citizen of our platform, you have to do these things, and just the fact that they track the law in many respects is almost incidental. And then, of course, things like taxation, users may well be warned to, get their own professional advice. So, just to add my 2 cents. Any other questions? Okay, well, great. Thanks, everybody, and please see us.